Intellectual property rights. What is intellectual property? Intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. IP is protected in law by, for example, patents, copyright, trademarks, which enable people to earn recognition or financial benefit from what they invent or create. By striking the right balance between the interest of innovators and the wide public interest, the IP system aims to foster an environment in which creativity and innovation can flourish. Jane Lambert, in her book Enforcing Intellectual Property Rights, defined intellectual property as the collective name given to the bundle of laws that protect the kind of investment in brands, design, technology, and the arts. Brands, design, technology, and creative works are known collectively as intellectual assets, and these investments give one business an advantage over another. Governments try to encourage these investments because they benefit the public as a whole. These brands help consumers identify the products and services that they really want, but it also helps in serving the business by providing a focus for advertising. Design makes things look better and sometimes helps them to work better. Technology provides the public with all sorts of new products and services as well as the new ways of making them. The arts, music, drama, literature entertain us and help us understand the world and ourselves. US intellectual property is increasingly at risk of theft as US firms become more integrated into the world economy and the production of more sophisticated processes and investments move overseas. High profits and technological advances have also increased the risk of IP infringements by making counterfeiting and piracy more attractive and easy to conduct. This figure depicts the primary US agencies and entities supporting US IP rights. US agencies use policy initiatives and enforcement activities to improve IP protection in the United States and abroad. Policy initiatives include reviewing IP protection undertaken by foreign governments and negotiating agreements that address intellectual property. The different types of intellectual properties are patents, trademarks, copyrights, and trade secrets. The first type of intellectual property is patent. It is the government authority or license conferring a right or title for a set period, especially the sole right to exclude others from making, using, or selling an invention. The next type of intellectual property is trademark. It is defined as a symbol, word, or words which is logo legally registered or established by use as representing a company or product. Examples include logo of Google and Facebook. The third type of intellectual property is copyright. Copyright is defined as a legal right created by the law of a country that grants a creator of an original work exclusive rights of its use and distribution. The exclusive rights are not absolute but limited. A major limitation on copyright is that copyright protects only the original expression of ideas and not the underlying ideas themselves. Trade secret. It is defined as a formula, process, device, or other business information that companies keep private to give them a business advantage over their competitors. Examples of trade secrets include soda formulas, customer lists, survey results, and computer algorithms. The next video will help us understand about the intellectual property rights.
Intellectual property rights are about more than just music and movies. They're in everything we do, make, use, eat, buy, and sell. Trademarks, geographical indications, patents, designs, and copyrights all support and promote our industry's economy, jobs, and innovation. IPR play an essential role in half of European businesses. And IPR support 1 in 3 jobs in the European Union. That's over 76 million jobs. IPR-intensive industries pay 40% more than other industries. Altogether, IPR-intensive industries contribute nearly 40% of the EU total GDP. That's 4.7 trillion euros. And that means more money for improving our communities. IPR-intensive industries account for 90% of the EU's trade with the rest of the world. IPR affect our daily lives in more ways than we can imagine. From creativity and innovation, to businesses small and large, to the economy in all member states. We all care about protecting intellectual property, and we can all contribute. Our everyday choices make a real difference.
The next video is of Christopher Brown, who advises Motion Touch about the importance of building of intellectual property rights.
How important is it to build intellectual property rights?
Well, I think it's vital, and have for a long time, because at the end of the day, every business has intellectual property, and the intellectual property is the rights to the product, the design of the product, perhaps a particular technology that's used, a particular design concept that's used in creating the product. But it's not as simple as that. It's also about concepts. For instance, if you think about the air miles concept, which was created some 20 years ago, all the branding, the speedboat logo, the coupon that represented 1,000 air miles or 10,000 air miles, all of that and the process by which the company entered into contracts with retailers and redeemers of the air miles, all of that was able to be converted into intellectual property, which then became a valuable asset. So in order to protect yourself from a competitor coming in and stealing your idea, your design, your technology, your concept, it is important to protect your brand name, your company name, and also the technology, the design that you use, and build that intellectual property up and be able to demonstrate at a time when you come to sell the company that you have secured it, it is protected from competitive threat, and therefore is valuable and is worth paying a premium in order to acquire it.
Copyright has a very long history. The entities protected under intellectual property rights have grown over time and are constantly growing. Intellectual property protects all these types of works, ranging from literary and dramatic works to engineering designs and sculptural works. These are protected from being reproduced and distributed without proper copyrights. It is also protected from derivative work, which is a work derived from existing work, and it is also protected from piracy and plagiarism. For works created after January 1st, 1978, copyrights are granted for a term of author's life plus an additional 70 years after author's death. For more than two authors involved, copyrights are granted for 70 years after the death of the last surviving author. Some of the intellectual property events in the news are Amazon filed a lawsuit against Barnes and Noble for express checkout. Amazon was granted a patent for one-click technology where customers can save their addresses and CC details and can check out without entering the details every time they shop with Amazon. Here have been several patent disputes surrounding one-click technology, including a patent infringement lawsuit filed against Barnes and Noble. Barnes and Noble offered a checkout option called Express Lane, which also enables shoppers to make a purchase with one click. The lawsuit was settled in 2002, however, the terms were not disclosed. In another incident, Apple sued Samsung in 2011 for infringement. 9% jury sided with Apple on a majority of its patent infringement claims against Samsung. Some of the patents which were infringed were universal search, background sync, slide to unlock, and automatic word correction. Apple was awarded $1.05 billion in damages. Similarly, Google is accused of selling the trademark name RescueCom as keyword to RescueCom competitors. The keyword was used to deliver Google-sponsored search results, therefore allowing competitors to appear on the results page when users searches for RescueCom. The lawsuit was originally filed in 2006 and dismissed by the lower courts. Both American Airlines and Geico have also sued Google over selling their trademarks as keywords. Both Bent and Lay alleged that Dan Brown, author of the best-selling Da Vinci Code, infringed on the copyright of their non-fiction work Holy Blood, Holy Grail. Because Brown had not copied the text of the earlier book, the claim was based on non-literal copying. The claimant's case was dismissed in 2006 with the judgment stating in part that there is no copyright infringement either by textual copying or non-textual copying of the substantial part of Holy Blood, Holy Grail. The Recording Industry Association of America (RIAA) sued Napster, a file-sharing site. Napster allowed users to share music files, and thousands of people began downloading songs for free rather than buying CDs. However, Napster did not own the rights to the music that people were uploading to its servers. The rights were owned by the recording artist and the recording studios. The RIAA sued Napster and won, causing Napster to close its servers. In another such incident, intellectual property rights battle happened between Mattel and MGA Entertainment Companies, who are the makers of Barbie dolls and Bratz doll, respectively. In the lawsuit, Mattel sued MGA claiming that MGA stole the concept and the name of the Bratz doll from them. The court sided with Mattel and ordered MGA to pay $100 million in damages. On the current event related to intellectual property, in August 2015, German sportswear giant Adidas made headlines last year for filing a number of lawsuits in connection with its famous three-stripe trademark. Defendants including Skechers, Marc Jacobs, and Forever 21 amongst others were accused by German sportswear giant of using its three-striped mark on their garments and footwear. Even though the color and the number of stripes is different, Adidas considered it as an infringement of its trademark. An array of recent trademark infringement related lawsuits initiated by Adidas includes matters against Shoe Branding Europe, Football Club FC Barcelona, Italian fashion brand Bally, fellow footwear brand Echo, Skechers, Marc Jacobs, and Elon Musk Tesla, among others. In November 2015, Adidas filed to voluntarily dismiss the lawsuit, signifying that the parties settled the matter amongst themselves out of court, thereby saving themselves the time and the financial resources associated with pursuing the matter to trial. The accused took the garments off the market and also agreed to forfeit a monetary sum in connection with the settlement. Forever 21 filed a complaint in U.S. District Court for the Central District of California, alleging that it received a letter dated 24th February 2017 in which Adidas counsel threatened to sue Forever 21 over its use of stripes on six items of clothing. According to Forever 21's complaint, it has fallen victim to Adidas threats on more than one occasion. Since 2006, Adidas has commenced a pattern of complaining about striped apparel sold by Forever 21, and it has steadfastly increased its threats to encompass virtually any item of clothing with decorative stripes. It added that Adidas is well known for aggressively enforcing its perceived trademark rights against others. On March 7, just after Forever 21 filed its declaratory judgment lawsuit, Adidas filed a trademark infringement lawsuit against the retailer in federal court in Portland. Interestingly, the complaint was filed under seal, meaning that it is shielded from the view of the public. However, we do know that it is in fact a trademark infringement matter. The court has since unsealed Adidas' complaint, which alleges that in addition to selling its own merchandise with allegedly infringing stripe designs, Forever 21 has offered repurposed Adidas products on its website, including women's athletic pants and shorts, which Adidas alleges are counterfeit products. Still yet, on March 13, Forever 21 moved to voluntarily dismiss its declaratory judgment suits against Adidas not because the parties settled, but as more of an administrative move.